Okay, hello everyone to the second ABL Corporations Law seminar. So I see some familiar faces, but also some new ones, So for those who've not been to the first one, so this is a new initiative that the faculty entered into from the start of this year. The idea was to, bring you more practical perspectives on corporations law into the unit, but also to, give ABL an opportunity to, I guess, showcase its, its various teams, its practice groups. So it's a combined event of dealing with particular areas of law, director's duties today, but also giving you some opportunities for networking, finding out more about the firm, and so on. So there will be a guest lecture of 1 hour, and after that there is, the networking event takes place outside in the foyer. So it's my great pleasure to introduce Jonathan Milner and Stephen Lloyd, yeah, who work as partner and senior associates respectively in the litigation and disputes resolution and restructuring and insolvency groups of ABL. Is that right?
Correct.
Yeah. And basically for the second part of the event, we've also brought Janine and Lisa, who are part of the HR team of ABL, and two first-year lawyers, Simon and Chris. Simon is an ABL, Monash alumna, and you can basically, of course, ask them all the questions that you might want to ask about what it's like to work in, basically in a large commercial law firm or in ABL particularly. Okay, the floor is yours.
Thank you.
Thank you very much for introducing us, and thank you all for coming today. I'm Jonathan. This is Stephen. What we're proposing to do today was give you a talk about directors' duties. We understand that's a topic you're studying at the moment in your corporations law course, but it's a huge topic. Obviously, we can't fit into 1 hour all of the things we'd like to tell you and that we would tell you. But what I would like to tell you, and none of you will believe me, because if you read the newspapers, people don't talk about this very much. Public company directors are a rare and endangered species. They have a difficult job and they are frequently very unfairly criticised. In my view, they're not adequately paid for the risks they take on. I know this is controversial, and I know this is not consistent with what Ken Haynes said in his Royal Commission report. They face difficulties, and even the most diligent directors face those difficulties. Really, the essential question for public company directors these days in particular is, how do I comply with my duties as a director in a way that is risk-free to me personally, but still allows the company to operate commercially? And by definition, operating commercially means taking some commercial risk, right? How does a director do that? And what are the risks of doing that? We want to give you a tangible sense today about some of the difficulties directors might face in trying to apply their duties as directors to particular fact situations. And I think that's the best way of getting a practical sense of how difficult it is to apply some of the theoretical concepts that you might be learning in your corporations law course. But before we do that, and Stephen and I will do that together, and I'll run you through a case study in a moment. I might even ask you some questions. Feel free to answer the questions. I don't ask the questions rhetorically. If anyone wants to put their hands up, put your hands up and try and answer the question. If no one wants to do that, I'll just answer the question myself. But I want to talk about 3 related concepts before we get to the case study that are critical to understanding some of the practical risks that directors face when applying their duties to particular fact situations. And these themes run through our talk today and run through all of the problems directors face. The first is directors are always judged with the clarity of hindsight, always. Now, you see in the slide that that's not permitted. There are lots of judgments where judges say, you're not to judge directors and whether or not they've breached their duties in hindsight and with the clarity that hindsight affords a judge. But Stephen and I are here to tell you today, and we can talk about some of the cases we've done if you'd like, and I'll mention some of them on the way through. Directors are always judged with the clarity of hindsight, and that's particularly the case where directors are judged by juries. And I'll come to that in a moment. So that's the first thing. What does that mean in a practical sense? It means that what may have seemed to be an immaterial issue for a director when they were considering making a decision gets scrutinised by armies of lawyers, people like us, but on the other side, and those issues often get magnified out of all proportion to the importance those issues had in the mind of a director when they were making the decision. That's the first thing. The second thing is directors tend to become a lightning rod for every sin committed by the corporation of which they're a director, whether or not they had something to do with it. The more high profile the issue, the more high profile the problem, the more serious the reaction and the more serious the consequences for the directors.
And the more pressure on the regulator to do something.
Exactly. The second thing to bear in mind as a broad conceptual theme is that at least in the case of the Section 180 duty of care and diligence, which you may have been learning about at the moment, the regulator, in this case ASIC, does not have to prove that anyone has actually been harmed in order to prove that the section has been breached. They don't have to prove that anyone's lost anything. Mere risk of harm is enough to engage the section. And we've got a case reference up there, I think, to ASIC and Casamitas, number 8. I'm not going to read out the passage, but Justice Edelman, now Judge of the High Court, made the position very clear. It's a position of quite long standing, but he made the position very clear. He said all the corporation's interests are relevant when considering the process of balancing foreseeable risk of harm against potential benefits. And Section 180 in particular does not require proof of actual loss to the company. Harm to its interests, and this is important, including its reputation, might also occur without the company being at risk of suffering any prospect of loss. That's an absolutely critical piece in all of this. And it's important because it informs how a director must think about how they comply with their duties as a director. If the standard is risk of harm, and that includes non-financial harm, the balancing exercise for a director is obviously much, much harder than it would be if they're just considering whether or not the company could lose money, or whether its shareholders could lose money in a direct sense, in a causative sense. How far into the future must the director look when considering these sorts of issues? What issues must the director consider? And we won't go through it now, but if you're interested, there is a very interesting opinion that you can find online that was written by Noel Hutley, SC, is a very senior sook at the Sydney Bar, and a junior barrister, about the extent to which directors should consider climate change, for example, when making decisions about things that affect the company. And that opinion, which is freely available and you should look at it, has just been updated. And essentially what they say is that sort of issue has to at least be considered by directors, whether or not they actually decide to do something about it. The final thing I want to say about, in terms of these broad themes and consequences, I'll touch on very, very briefly, because we'll deal with it again when we go through the talk, and that is, I think we've made a very short note there in the third bullet point. Directors face serious consequences for breach of directors' duties, and those consequences have become harsher recently and are only likely to get worse. And that does not mean that directors can go to jail for every breach of directors' duties. I'm sure you're learning about this in your course, but you should not assume that because misconduct doesn't carry the risk of jail time for a director, that a finding of breach for a director is not an absolutely catastrophic, life-changing event. Our experience is that when directors are charged, whether or not it's a criminal proceeding or a civil penalty proceeding, the mere fact that they're charged by ASIC and the mere fact that ASIC commences proceedings against the director means that their life has changed forever, and we will explain some of those issues for you in a moment. So, before I turn over to Stephen to give you a bit more of an overview about what we're going to talk about today, the point I'm trying to convey to you is that despite what you read in the newspapers, despite what you may hear from people around the place, public company directors are not just overpaid ignoramuses who do all of their best work on the golf course. Some of them are, some of them do, but most of them aren't. They have a difficult job, as we'll try and convey through the case study.
Yeah. So before we go to the case study, I'll just run you through very quickly what we're going to talk about. We're going to talk about the sources of the duty, which no doubt you're all aware of as you're going through your course. And the point we're making today from a practitioner's perspective, and we're looking at it today in our case study from the perspective of acting for a director who's being pursued by ASIC. Of course, directors also get pursued in shareholder class actions or just investor litigation. But for practical purposes, we've run many of those kind of cases, Jonathan, more than I have. And you don't need to pick the Corporations Act up and claw through it and wonder about Section 180, 181, 182, 183, and then how they differ from the common law duties, because they will all be pleaded, they're all in play, and really there's no practical difference. If you're found to have breached one, it's likely you've breached, at least in Section 180 and 181, you've breached them both, because it's hard to see how you could fail to meet the standard of due care and diligence, but then also be found, on the other hand, to have acted in the best interest of the company in good faith for a proper purpose. So the point is, these fine distinctions in the cases between this cause of action and that cause of action in practice don't tend to play out. What matters is what happened, what should have happened, what were the consequences of what happened. And the battle is usually factual rather than legal. Obviously, you plead every point you can, but from a practical perspective, it really is about the facts and what should the director have done in the position they were in. We are going to be also talking about the consequences for directors, civil penalties, fines and jail, and we'll take you through those briefly towards the end, and we'll talk about some ancillary practical issues. These are up in lights at the moment because of the outcome of the Financial Services Royal Commission, and ASIC has changed its policy, and we'll talk a little bit about the culture that is emerging at the moment from the statements ASIC has made. But ASIC's new view is, why not litigate? Whereas in the past it's taken a conciliatory, cooperative approach to dealing with breaches of the Corporations Act. It says no more, and now it's LinkedIn's full of ads for investigators and enforcement lawyers, and they're coming, and the targets are going to be directors. In the final report from the Commission, Commissioner Haynes said the following: if you've heard him speak, you should pretend that I'm reading it out in his beautiful voice. There can be no doubt the primary responsibility for misconduct in the financial services industry lies with the entities concerned and those who manage and control those entities, their boards and senior management. Nothing said in this report should be understood as diminishing that responsibility, and everything that's said in the report should be understood in the light of that one undeniable fact. It is those who engage in misconduct who are responsible for what they did and the consequences that followed, which is scary if you sit on the board of the CBA, if you think of the scale of that beast that you're responsible for and the things that happened there. But ASIC is not going to hold back. So let's get on with the case study.
All right. Let me run you briefly through the case study that we want to talk about today. I should say before I do this case study is based on an actual case that I've done. Stephen was involved in it. This is a while ago. Stephen was involved as a more junior lawyer. So he's familiar with the facts as well. It's real. I've anonymised it because I don't want any of you running back to my client's daughter who may or may not be a student at Monash or somewhere else and say, I've relied on this case. But it was a particularly interesting case because it raised a whole lot of very interesting directors' duties issues on both sides of the transaction. You'll understand what I mean by that in a moment when I run through it. If any of this is unclear to you, because the businesses, as I'll explain to you, sort of complicated businesses, put your hand up and ask me, and I'll hopefully be able to explain it to you, but it's important that you understand the case study. So there are two companies. One is called Ramjet and the other one is called Asset Co. And they run broadly similar businesses. They have businesses which we would call asset origination and principal investment business models. What that means in practical terms is they buy assets on their balance sheet. So the company itself buys the assets. The company then seeds a listed trust with that asset and effectively sells the shares in their trust on the market to investors. Investors invest in the trust and they roll over the debt that they've used to buy the assets, and investors generate a return, and they generate management fees. So both of these companies, ASIC and Ramjet, run these businesses. Ramjet runs a business that's focused on commercial real estate. ASIC runs a business that is focused to some extent on real estate, but they have a range of other different asset classes where they do this aviation, infrastructure, rail, those sorts of things. ASIC happens to own 20% of the shares in Ramjet, and ASIC is a listed public company, okay? So these businesses are very closely related. The other shares in Ramjet are owned by companies associated with Ramjet's managing director. You'll hear this name, I think it's up there somewhere, Alistair Caldwell, okay? Again, it's anonymised, there's no person called Alistair Caldwell. Don't go Googling Alistair Caldwell, it's not the same guy, okay? Alistair Caldwell is a director of Ramjet. He owns most of the shares, he's the managing director, and he's a director of Ramjet. He's also a director of ASIC. Right? Remember, ASIC owns 20% of the shares in Ramjet. Okay? ASIC is a much larger company than Ramjet, and it's also a significant lender to Ramjet. So when Ramjet is looking to acquire assets to seed these listed property trusts, it obtains in part funding from ASIC. Not all of its funding, mind you, that's important, some of its funding. ASIC decides one day, one of its executives gets a bright idea that buying Ramjet would be a natural fit because their real estate division is not very well progressed, it's not doing very well, and they want to buy the shares in Ramjet that they don't already own. Who owns the shares in Ramjet that ASIC doesn't own? Our friend Alistair Caldwell, okay? Do people see the problem? Does anyone see the problem? Right, you're doing your director's duties at the moment. There's a problem. There's a conflict between Mr. Caldwell's duty to ASIC and his duty to Ramjet. He's a director of both companies. And there's also a conflict between his duty to ASIC and his personal interest. So you might have learnt about conflict between duty and duty and duty and interest. He's got both problems, okay? Everyone recognises the problem. These companies have got very sophisticated people involved with them, very good advisors. They recognise the problem and they decide, well, there's an ASIC regulatory guide, RG 76, and it says related party transactions are okay, they're kosher, you can do them if you follow the rules. People think, well, what are the rules? Let's go and speak to our top tier advisors. Not ABL, I might add, others. Less top tier, but still top tier.
We would have told them the same thing.
We would have told them the same thing. And they exercised a lot of caution. I'll give you a bit of an illustration of what they did. They expressly, when I say expressly, I mean there was a minuted at a board meeting, they expressly consented to Caldwell negotiating the transaction solely on behalf of the Ramjet shareholders, and they, as I said, they minuted that decision. They introduced very prescriptive protocols at an ASIC level, which stated that Caldwell couldn't vote on the transaction, couldn't attend board meetings on the ASIC side of the transaction in relation to the transaction, couldn't receive minutes of those board meetings, could only receive information about the transaction as an independent vendor. Right? He's selling his shares. We're going to treat this as a commercial transaction completely at arm's length. The ASIC directors expressly authorised, and again this was minuted, Caldwell to act solely in the interests of the Ramjet shareholders to the exclusion of ASIC and its shareholders. So that was made clear before the transaction kicked off, before a price was negotiated, before anything was done. ASIC had a very well-resourced internal deal team who understood the market. They operated in an identical market, including the credit market, so the people that they went to raise money. There was excellent external advisors, there were investment bankers, there were lawyers, there was accounting firms. There was an incredibly thorough due diligence that took place over about a course of about a month. Caldwell made a management presentation, which often happens at the commencement of these sorts of transactions, to ASIC, where he listed all of the issues that the business faced, some of the risks that the business faced in a generic sense, not specific risks, but one of those risks that he outlined was credit market risks, which basically means can we roll over debt, can we refinance debt, can we find money from people because the business relies on people giving it money, refinancing that money, putting assets in listed property trusts. And there was an extensive share acquisition agreement that was negotiated. There were warranties in the agreement. There were conditions to completion. There were qualifications and limitations on what claims could be made for breach of contract. All the sorts of things you'd normally see in a deal like this were negotiated, and they were negotiated at arm's length with both parties properly advised. After all of this was done, if that wasn't enough, ASIC Co put the deal to its shareholders, said, we want you to tell us whether you approve the deal, we want you to vote on whether the deal should proceed. And as part of that process, they provided the shareholders with an independent expert report, again, a top-tier investment banker, and the independent expert said, we think this deal is fair and reasonable, which is what they're required to say under the Corporations Act, and the shareholders approved the deal. Right? All good so far? Everyone agree? No problem? Transaction was widely publicised. It was a big deal, and Mr. Caldwell walked away with a small fortune, right?
Disagree that it was small.
A large fortune. He did very well from the deal, and his timing was impeccable. Now, any M&A lawyer, mergers and acquisitions lawyer, like if you had Jeremy and Jonathan, who some of you may have seen the last time, come in here, until we told them about these cases, if you had them in here, it's a textbook related party transaction, absolutely nothing wrong with it. So what's the problem? Does anyone know what the problem is? Can anyone think of what the problem might be? It's not obvious. It's not obvious, right? The problem, to put it bluntly, is that at the time the transaction was being negotiated, some of Ramjet's debt, so that debt that they used to acquire assets, needed to be refinanced or repaid. All right? It didn't need to be refinanced immediately, but it was looming, so it was coming up within the next few weeks, few months. Now that wasn't unusual. That was in the nature of the business. This happened all the time. Debt was refinanced constantly, and ASIC Co knew that. Caldwell considered that refinancing the debt that was due wouldn't be a problem. He was speaking to a raft of prospective lenders. They'd all expressed tentative support for a refinancing. The current lender had expressed support for continuing, but credit market conditions were tightening. Now, the time period that we're talking about is late 2007. Okay? Does anyone know what happened in late 2007 and early 2008? I don't know if it's too early for you guys. GFC. What Australians call the GFC. You know, the Americans don't call it the GFC. When you talk to American lawyers about the GFC, they look at you blankly, like, what are you talking about?
What do they call it? It came up all the time.
I don't know.
We had American witnesses and we kept saying GFC to them and they kept using some other term.
So credit market conditions were tightening. What happens when credit market conditions tighten? It's more difficult to roll over debt. It's more difficult to refinance debt. But remember, I'll come back to this in a moment, ASIC Co and its executives and directors and all of its advisors operated in exactly the same market. They also knew credit market conditions were tightening. They also knew it was getting more difficult to refinance debt. Now, within months of this transaction completing, ASIC Co was in serious financial strife, largely as a consequence of the GFC. Credit market conditions by that time hadn't just tightened, they had frozen shut completely. Anyone watch Game of Thrones? Like that? The wall, right, had come up. No one was lending money to anyone. This was the GFC, as you mentioned. One problem ASIC Co had at this point in time, of many, by the way, is that Ramjet was now a subsidiary. They had bought the company. They needed to refinance the debt and couldn't do it because credit market conditions were closed. Credit markets were closed. It asked ASIC Co to assist it by providing money for it to enable it to refinance this debt. But ASIC Co was under serious financial pressure. It was short of cash. It couldn't refinance the debt, and it collapsed. It collapsed into a spectacular high-profile voluntary administration and liquidation, not because it couldn't refinance the Ramjet debt. It had all sorts of problems. That was just one problem, but that was one contributing factor to this problem. Now, not long after Asset Co collapses into liquidation, Mr. Caldwell receives a call from someone claiming to be a member of ASIC's enforcement team, which is always a sobering moment for a public company director. Fast forward a few weeks, he's been compulsorily examined by ASIC. Some of you may not know, but ASIC has the power to call anyone in under compulsion and examine them. You're required to answer questions. You can't claim the privilege against self-incrimination. You have to answer questions, and you have to answer all of the questions if they're relevant to the examination. Now, I'm not making this up, this is true in this case. They didn't give him anything to eat. The water was warm. The coffee was terrible. He went a whole day without a glass of wine, which is tough for this guy. Okay? They didn't even give him 5 minutes to go and move his E-Series Merc out of the garage. And the garage closed overnight. He'll leave his car there overnight, right? This was sort of like new territory for this guy. He had no idea that this was even possible. In fact, I was sitting there with this guy while this was happening, and all the lights went out at about 6 o'clock, because in those days, this doesn't happen at ASIC anymore. They work hard these days. In those days, 5 o'clock, 6 o'clock, it was done. So the lights went out, and everyone was relying on a thin shaft of light from the emergency light to illuminate all the documents. Anyway, I asked him some difficult questions. He was extremely worried, and so he turned up at the lawyer's office and he asked the lawyer some questions. Now, these are not exactly the questions that my client asked, but these are the sorts of, I'm not making this up, by the way, these are the sorts of questions that Stephen and I get asked all the time by our clients who find themselves in the middle of an ASIC investigation. You see the first few? Who's going to pay? Can they take my house? Can we settle this? They quickly get to the last few questions and they ask them over and over and over again, can I go to jail? Will I go to jail? And the reason directors ask those questions is because the prospect of jail influences decisions. There's no doubt about it, right? So I said that being charged by ASIC can have catastrophic life-changing consequences. It can, and that doesn't require directors to serve jail time, but jail time is a very powerful influencing factor for these guys. The other thing these questions reveal, if you think about it, is that many directors don't believe they've done anything wrong in a moral sense. Right? They don't recognise subjectively that they've engaged in any misconduct whatsoever, and that's certainly the case here. Now, before I turn over to Stephen, obviously, our director asked a whole lot of questions of his lawyers, and the lawyers have to answer those questions. Well, what do you say? Before you can answer those questions, you have to understand what it is that ASIC thinks he's done wrong. Does anyone want to venture a guess? What do you think ASIC's case theory is? Anyone? What does ASIC think he should have done? ASIC thinks he should have said something. Said something about the fact that short-term debt needed to be refinanced and credit market conditions were tightening. Okay? Let me be more precise, though. ASIC claims that Mr. Caldwell owed a duty to Asset Co to exercise due care and diligence in the discharge of his powers as a director of Asset Co under Section 180 and its common law analogue. And they claim that he owed a duty to Asset Co to act in good faith in the best interest of Asset Co. Now, pause there in a vacuum, that's pretty uncontroversial. He's a director of Asset Co. Those duties are expressly set out in the Corporations Act. He owes those duties, but ASIC goes further, and this is where we start to get into controversial territory. They say that his obligations to Asset Co, remember he was acting in the interests of Ramjet, his obligations to Asset Co were neither satisfied. Go ahead.
Just as part of the due diligence process, wouldn't the independent report in the scheme of arrangement have shown that information?
I'll come back to that. It's a great question. It's exactly the question that, but hold that thought. I'll come back to that in a minute when we're talking about whether or not Mr. Caldwell's really got a problem here or not. Okay, but it's a great question. But let me just go back to let me just finish ASIC's case theory. So they say he owed these duties, not controversial, but they say that his obligations to Asset Co weren't satisfied or removed by his disclosure of his conflict of interest, by his exclusion from the decision-making process about the transaction, and from Asset Co agreeing to that on an informed basis. They say it's not good enough. They go further and they say it's actually irrelevant. They say that Asset Co, it's irrelevant that Asset Co had a raft of advisors. It's irrelevant that Asset Co knew the industry in detail. It's irrelevant that they had access to these facilities that needed to be refinanced and was familiar with the credit market conditions in which Caldwell was operating. They say he had an obligation to tell Asset Co about these issues at the time he found out about them. Okay? And he had an obligation to tell Asset Co about those issues in his capacity as a director of Asset Co, not because he was a counterparty to a transaction who was going to be sued potentially by the company for a breach of a warranty or for misleading deceptive conduct or something like that. No, he had an obligation as a director, they say, to tell them these things. Now, Mr. Caldwell was once a high-flying M&A lawyer, and then he became an investment banker, and he's actually consulted his ancient copy of the Corporations Act. It was annotated, got it back in the 70s. He even consulted some old edition of Equity Doctrines and Remedies, to figure out what the fiduciary duty concept involved. And he turns up and he says, listen, read this. It says here that a person in a fiduciary position will be absolved from liability for what would otherwise be a breach of duty if they get informed consent from their principal. So what's the problem? And it also says that the information that I need to disclose to the principal to get their informed consent isn't this information that ASIC says I should have disclosed. It's rather the nature and extent of my conflicting interest, which he did. Everyone knew what the conflicting interest was. Gives you a few case references. Might even give you a reference to, Commonwealth Bank of Australia and Smith, not that old, but old enough. And of course, what do you do then? You sort of get a little bit nervous. It sounds right. It's consistent with my understanding of directors' duties and fiduciary obligations. But in the back of your mind, you remember that there might be a few cases that are going to cause you a few problems. So what do you do? Anyone? I'll tell you what you do. You ask your very clever senior associate, Stephen Lloyd, to go and look at all the cases, and he'll tell you a bit about them now.
So the nagging problem is that there's a long line of hard to follow appellate cases which suggest that a director can't extinguish or completely attenuate their duties. And what that means is you can set up all the things Mr. Caldwell set up here, but at the end of the day, he was still a director of Asset Co, and he still was subject to some core duties that he couldn't get rid of. That's ASIC's case, essentially. There's also the point that comes out of these cases is this prescriptive and proscriptive distinction, which is the Breen and Williams argument, and people have a lot of fun with it at universities, is of no assistance in analysing whether a director's breached their duties. So it's not enough to say, well, a fiduciary doesn't have prescriptive duties to disclose things. They just have a proscriptive duty not to do certain things. That's all great and true if you follow Breen and Williams, but doesn't matter. If you can't offload the duties altogether, well, what are they? And like all good questions, and you'll learn this once you start practicing law, the best and early answer always has to be, well, it depends on what was happening. What are the facts? I need to know them all. And in these cases, that's exactly the situation. Whether he has duties remaining after they've set up all these related party transaction things and what the content of those is depends, and you can't state it in the abstract. It has to be worked out, and that's what makes these cases so difficult for directors, because their lawyers are not going to be able to say to them, don't worry about it, you're fine, because it really is going to depend on what comes out in the evidence and what was happening at the time. And the problem that Caldwell has here is that he's in two conflicting positions, which fiduciaries should avoid at all costs. And a lot of judges are leaning towards this view that you can set up all the informed consent you want, but you cannot and should not take on conflicting fiduciary duties, particularly in the context of lawyer-client obligations. There's informed consent isn't going to help you in those circumstances. We've set out some cases there, which are kind of the classic cases on these kind of questions, which you can look at later, and we're not going to take you through them. And ASIC actually publishes a regulatory guide about related party transactions, which refers to all these cases. How long is the regulatory guide?
Not all of those cases.
Some of them?
Regulatory Guide 76, when I was doing this case, buried deep in the regulatory guide is one small paragraph which says something like, in certain situations, a director can't just absent themselves from the transaction and act inconsistently with the principal's interests, but it depends on the facts, and cites, I think in particular, Permanent Building Society in Wheeler and Permanent Building Society in Magee, which is all emerged from the collapse of the Permanent Building Society in the 90s. I should probably talk to them, tell them briefly about Fitzsimmons, but one of the cases we referred to in that list is Fitzsimmons and the Queen, and you see a lot of these decisions were published in the 90s. But the difficulty a director faces in this situation, and the idea that this is so highly fact dependent, is exemplified by what Justice Owen said in this Fitzsimmons decision, and it was an appeal court decision. He was one of the judges, but he said this, and I'm going to read it out to you, and you'll see what I'm talking about. What action, above and beyond mere disclosure, the director must take will vary from case to case. Thanks. That's very helpful. It may not be enough for a director simply to refrain from voting or even to absent himself or herself from the meeting during discussion of the impugned business. The circumstances may require the director to take some positive action to identify clearly the perceived conflict and suggest a course of action to limit the potential damage.
Yeah, which is like...
It's like wrestling a piece of jelly. Yeah. What action? What do you do?
What does it even mean to say to identify the perceived conflict?
Yep. And what if identifying a course of action would assist the principal but harm another party to whom you owe duties? Now, remember, Mr. Caldwell's in a position where he owes duties to two companies, to AssetCo and to Ramjet. On one view, giving the information to AssetCo will result in a lowering of the transaction consideration and the price. That's not in the interests of Ramjet, and there are quite prescriptive protocols in place. There are negotiations around warranties in a share acquisition agreement. There are limitations on claims that can be made. I mean, he's negotiating for the vendors the best possible commercial outcome, just going along to AssetCo and giving them a whole lot of information that might affect the commercial position of Ramjetco's shareholders, or giving them information that's confidential to Ramjet that AssetCo is not entitled to, might give rise to a breach of other duties. So you see the real bind that Mr. Caldwell might have found himself in. So how do we analyse his position? Well, if, you think to yourself, this is all a little bit worrying, but we better tell Alistair what's going on here. We've found all these cases, and so you get him in. And you tell him, look, this is a textbook, there's that word again, textbook related party transaction. There's nothing more anyone could have done. I think you're in the clear. I think you're okay. What factors do you think give you confidence when you're advising Mr. Caldwell that he doesn't have a problem here? Anyone want to venture a guess?
We had the question here, which hit it on the head.
Yeah.
So there's a data room, and these loans are in it.
Yep.
They had all the information they needed to know when these things were due to be refinanced, and they're moving in the same market, so they know that credit is tightening and there'll be a due date for these loans. So they know that. That information's there.
Exactly right.
And so what's ASIC's case? You have to tell them.
Exactly right. Exactly right. So the decisions that Stephen referred on the previous slide all characterised by no protocols, no related party protocols, sloppy protocols.
Permanent building societies, like deliberate non-disclosure.
Deliberate non-disclosure. The principal being reliant on the conflicted director who knows all about the business, knows all about the transaction, and the principal knows nothing about transactions like that, or nothing about the industry, or nothing about the market in which they're operating. What it boils down to in those cases is vulnerability. The principal is vulnerable to the knowledge that the fiduciary has, right? And so you think to yourself, this is distinguishable. ASIC is not vulnerable. ASIC operates in this market. It knows about this industry. It's got top-tier advisors. It's got a due diligence room that's overflowing with information. It's got access to the facilities. If you think to yourself, if any of this was important to ASIC at the time, that is, if the status of the facilities was important to ASIC at the time, it could have asked about it. It could have reviewed the facilities and figured it out itself. It could have insisted on a warranty in the share acquisition agreement to cover this eventuality. In other words, it was able to look after itself without Alistair getting involved and dishing up all this information. You think to yourself, the fact that it chose not to do so must mean that at the relevant time he didn't care. And that was our case. That was our defence, part of our defence. It did not care. It didn't care because this was a drop in the ocean in terms of the debt that would need to be refinanced early in the new year. It became an issue later, and I'll come to that in a moment. But there are still two problems. There are still two problems for Mr. Caldwell, and you recognise this. The first is a decision of the New South Wales Court of Appeal in Duncan and ICAC. And we're probably going to run out of time, but Duncan and ICAC was not like the other cases. There were pretty good related party protocols in place, and there was a business that knew the industry. And this I don't know if it's familiar to all of you. Does the name Eddie Obeid mean anything to anyone here?
Yeah.
Anyway, so this is the case about Eddie Obeid, and the argument was that the three conflicted directors of White Energy wanted to acquire Cascade Coal. The three conflicted directors who also owned shares in Cascade Coal didn't tell the other directors about Eddie Obeid's involvement at Cascade Coal, and Eddie Obeid's involvement at Cascade Coal down the track led to the whole thing unravelling and the New South Wales government introducing legislation to effectively take all of the coal exploration licences that Cascade Coal had and cancel them. So it turned a company that was worth hundreds of millions of dollars into a company worth nothing, right? So in that case, the related party protocols were pretty good. The situation was dealt with quite tightly, and the New South Wales Court of Appeal overturned a decision of Justice McDougall and said the directors remained directors of White Energy. The duties that they owed to White Energy weren't extinguished or attenuated, and that they were obliged to disclose Obeid's involvement in Cascade Coal. Now, you're still, I think, pretty comfortable because the circumstances of our case can be distinguished. And they can be distinguished in particular by the fact that the information that ASIC says should have been disclosed to ASIC Co could have been found by ASIC Co, whereas how could White Energy have found out about Eddie Obeid's involvement in Cascade Coal? So you're probably okay, but the second problem is a practical problem. It's not a legal problem. And it comes back to something I said at the outset of the talk, and that is that it involves our old friend, Mr. Hindsight, right? Everyone's wise after the event. What happened to ASIC Co? We know that ASIC Co collapsed into a spectacular liquidation. And one of the causes of the liquidation was its inability to refinance debt, its inability to secure appropriate cash flow, effectively like balance sheet problems, right? Minor problems, and this was a minor issue, refinancing this facility, were recognised later with the benefit of hindsight as hugely material latent risks to the business.
Jonathan and I ran a Babcock and Brown related case where the lending in the transaction was more than $1 billion US, and they struggled to refinance an $11.3 million mezzanine loan. 11.3, which is the kind of money that the people at Babcock and Brown carried on them.
Yep. And
in hindsight, the case was, well, you had to disclose that. This was a disaster. Everyone needed to know about it. 11.3 mil. And that case ran and settled late, but there was a huge case fought over this tiny little thing, and only in hindsight did that thing matter. It didn't matter.
Tiny is a relative concept. $11.3 million.
Yeah, I would like it. I would like it.
To me or them or anyone else, right? But it's in the scheme of the corporation and the sort of debt that it was carrying and the nature of the business model and the value of the assets that it was owning. So it's a hindsight problem, and we'll come back to some of the issues that poses for directors. But you can hopefully see the problem for our director. He didn't think he was doing anything wrong. On one view of the law, he didn't do anything wrong. You had a counterparty who was perfectly able to figure this all out for themselves, but all of this conduct will be judged by a judge or perhaps a jury, which is probably even worse, with the clarity that hindsight gives us, and even though it's not permitted, recognising that you've now got a big problem where if it's judged at the time, it's not a big problem at all. Mr. Caldwell's not the only person with a problem. There are some others who may have a problem too, and Stephen will tell you about them now.
So we're jumping slightly out of our case study to the other side of the fence, to the non-executive directors of ASIC Co, and I'll touch on it, the executive directors as well. So they are, on the ASIC Co side, responsible for assessing this transaction, and as we pointed out, they had all the information at their fingertips that they needed to reach the conclusion that there was an upcoming refinancing problem, and yet they went ahead with the transaction. There is a distinction between executives and non-executive directors because, as you're no doubt aware, Section 180, although it's objective, it's an objective test applied in the circumstances that the director was in, and one of the important circumstances that you are in is you're an executive director, meaning you're the CEO, managing director, whatever it might be, with your fingers right in the pie, running the business, you know it all. Or you're a non-executive director who gets board reports prepared by management, and you read those, you ask questions. That's an important factor that's taken into account when we're assessing the content of your duties under Section 180. The irreducible core, the second bullet point, this ties into reliance on management. In ASIC Co, the non-executive directors we had a subcommittee set up to assess this transaction. Management was all over it, doing the DD. They presented a report to the board saying, go for it. To what extent could the non-executive directors rely on management to have done the DD and looked at it? And there's a case, Centro, which is an important one for anyone advising directors, which says there is a irreducible core of director duties which require as a minimum competence and diligence. In the Centro case, the problem was that the board approved financial statements which omitted a couple of important matters, totaling $2.5 billion US, being the difference between debt that was repayable this year and debt that was not repayable in the next 12 months, non-current and current assets. And in that case, the non-executive directors said, we relied on our auditors and we relied on management, and the court said that doesn't matter, you had to know the basics because you're responsible for the accounts. And so Section 180 required that you at least understood the difference between what's non-current debt and what's current debt. And they were hit with, ASIC prosecuted them and got huge fines against each of them. And every director of every large company in Australia panicked because assessing the accounts of a large company when you have someone like Deloitte or KPMG auditing them is a scary prospect that even when they make a mistake that filters up to you, you are then personally on the hook and ASIC prosecutes you because you relied on them and they were wrong. And
does every non-executive director need to be an accountant?
Yeah.
And if they don't, what do they need to do to put themselves in a position to actually understand a set of accounts, read them, and figure out whether there's a problem with those accounts? So that's hence the panic, I think.
Yes, and a distinction between our case study and the Centro case is that the Corporations Act requires directors to sign off on the accounts, and that was an important factor. It wasn't just that they had to run the company and act in the best interest of the company. They had to sign off on the accounts. They had all the information which should have told them that the debt was not properly disclosed in the accounts, and they didn't do it. Here, it's different because we're not talking about a specific statutory responsibility that can't be delegated. What we're talking about is a transaction. They set up protocols, they were supervising it, management recommended they enter into it. There was a problem that should have been put up in lights with the benefit of hindsight that wasn't. So that's their issue. Let's say there was a managing director, CEO, running it. The standard expected of her is going to be higher than on the non-executives, because she will be expected to have far greater detailed knowledge of the financing and the relevant loans and the credit market than they were. But the actual duty remains the same: care and diligence.
And I should say, for a non-executive director, and we're facing this at the moment, I'm acting for the Dick Smith non-executive directors, and one of the critical things that will be asked is, should they have known? That's really the essential question when you're talking about a non-executive director and a breach of Section 180 in exercising care and diligence, is that were they on notice of something that should have caused them to ask further questions? That's what it boils down to. In this case, when Stephen's looking at this case study, probably not, if you're talking about a non-executive director. But if you imagine another piece of information being conveyed to them, even if it's pretty obscure, that puts them on notice that there might be an issue with the refinancing of the short-term debt, then maybe they've got a problem.
So what would Alistair say in defence? So the best defence to any case brought against you is to say, I didn't have that duty. I complied with all the duties I had. You're wrong. It didn't need to be disclosed. It didn't matter. You want to win there, because once you're talking about these defences, you've lost. And now you're trying to somehow, after losing, make it okay. And the reality is all of these, ratification, informed consent, perhaps slightly different, but if you're going with business judgment, reliance on others, or the honest guy defences in 1317S and 1318, good luck to you. They sound good, but no one wins on them. They're not a good defence.
They're always there. They're always pleaded in your defence, and they almost never succeed.
Yeah.
All right. That's why we've said in bullet point number 3 that, in a practical sense, that these are the last refuge of the desperate defences in a ASIC, in particular in an ASIC prosecution.
I think, given timing, I'm not going to step you through these in great detail. The ratification and informed consent, again, this is an area that's kind of interesting interaction between common law and statute, because if we have an irreducible core for Section 180 and 181, the informed consent point is difficult, and we've already talked about ICAC and Duncan, which is really right on point for that. If you're getting shareholders to ratify it and getting informed consent, but ASIC's case is there was a material non-disclosure, then your ratification and informed consent the case is weak, because it wasn't informed consent and they ratified something without knowing what it really was. Business judgment rule is a Section 180 specific, which lets you off the hook essentially if you had to make a call, you made it, it was reasonable, and it just went wrong. But again, by the time you're relying on that, you've already been basically found to have breached your duty. And then you're trying to say, well, in all the circumstances, I had to make a judgment, and it was one that could reasonably be made in the circumstances. The problem as well is you have to have made a judgment. There has to have been some judgment. Here, the NEDs have made a judgment to approve the transaction, but there's also the point of, was their decision not to interrogate the refinancing schedule, is that a judgment that they can rely on for the business judgment defence? So it gets quite complex. Reliance on others, we've already touched on. It's better for the NEDs, but there is that irreducible core problem raised in Centro. And the honest guy defence is, let's run that for Alistair. I didn't disclose something that should have been disclosed. It dragged both companies under. People lost heaps of money, but I didn't really mean for anyone to lose money, and I acted honestly, so why don't we just say it's all square? That's not an attractive argument, and 1317S and 1318 kick in when you've already lost the case.
If anyone knows any judges who would accept that defence for Alistair, let me know.
That's not how we
do forum shopping some of our clients.
It's not how we write it in the defences, but that's essentially the argument.
Yeah. Let me just race through because we're running out of time, and I should say that if we run a bit over and people need to leave, feel free to just walk out of here. We'll try and race through this, and if people have questions for us, we can answer some of them during the networking. But let me just say this about the civil consequences. The civil consequences are significant and have recently been made much more significant. So, for example, the fine for a breach of a civil penalty provision is now over $1 million, whereas before it was about 200 grand for each breach. And that's a lot of money in anyone's language, even though Stephen was throwing around $1 billion, $11 million. That's a lot of money. Secondly, even though for a breach of a civil penalty provision, a director can't go to jail, the flow-on consequences for directors of being found liable for breach of a civil penalty provision are absolutely life-altering. Directors in Australia don't get second chances, by and large. They do in other jurisdictions, but in practical sense, they don't get any second chances. In fact, whether or not the regulator succeeds, usually the mere charge, as I said at the outset, is absolutely fatal to their career as a non-executive director. There are other financial consequences that aren't directly related to the case in relation to insurance and indemnity and whether or not you have to pay defence costs back to people if you lose, which are also hugely material for directors. And this is it's a massive issue. I have personally seen it. I've personally been asked by directors how they're going to communicate these things to friends of their children, to people at school, all of those sorts of things. It completely alters their life. And don't believe anything you read in the papers about directors getting a slap on the wrist. It's not like that. The next, perhaps we move to the next point, because it's a point that Alistair has been noticing that you haven't yet answered. Am I going to go to jail? Right? I think it's a difficult question to answer. The answer I gave this client is absolutely not. No chance. You're not anywhere near that territory. Would I give that? Does anyone want to actually know, I should say, what actually happened at the end of the day to this guy? I can tell you, because this case study assumes that there's been a charge. ASIC didn't even proceed with a civil penalty charge. The investigation concluded, and that was the end of it. I'd like to think that's because of great ABL lawyering, but I don't think the same thing would happen today, all right, in the current regulatory environment. So the answer I gave this guy is no. I don't think I would say the same thing if I was presented with these facts today. There are a whole range of different provisions in the Corporation Act that can give rise to criminal liability for directors. Usually people think about Section 184, which you'll all be studying, which creates a criminal penalty for directors in circumstances where they breach the other director's duties, 180 to 183, dishonestly or recklessly. And bear in mind, I won't go through it now, bear in mind there's a new definition of dishonesty in the Corporations Act as a result of the introduction of that recent act.
Treasury Laws Amendment, Strengthening Corporate and Financial Sector Penalties Act. So bear that in mind, but I don't, and it's now a single limb test, but I won't go into details about that. But I don't think if I were advising Alistair, I would say that he has engaged in dishonest or reckless conduct in the circumstance of this particular transaction, given what's occurred. But there is much lower hanging fruit for ASIC in this general territory when we're talking about
criminal liability for directors. And people tend to overlook these sections when we're talking about directors' duties. Section 1309 and in fact Section 1308 are highly relevant. Peter, some of you may have heard about Peter Gregg. Peter Gregg, anyone? Peter Gregg is the former CFO of Leighton, which is now called CIMIC. He was recently found guilty of breaching Section 1308 by a jury in New South Wales. That was late last year. I acted for the former CFO of ABC Learning. Anyone remember ABC Learning? Yeah, ABC Learning. So he was charged under Section 1309 and he took a plea and managed to stay out of jail, but has a criminal record. You'll see, without going through it in too much detail, the critical provision or the critical part of that section is that the officer or the employee knows that information they're providing to a director or an auditor or ASIC or a whole range of people is false or misleading in a material particular, right? And if ASIC can, or information they provide has admitted information that is false or misleading in a material particular, that is a criminal section, which gives rise to the risks of jail and those sorts of things. And ASIC is increasingly looking at those sorts of sections in the Corporations Act rather than the directors' duty sections when thinking about sheeting home liability to directors. And if you think about this case, if Alistair was sitting in a room with one of the Asset Co directors or the managing director, and he was asked questions about various things and chose not to say anything about the difficulty that they might face in refinancing this facility, I would be worried about that section if I were him. I would be worried about ASIC turning around and saying, you had information, you knew it was misleading, and you didn't tell anyone, because you're right in that territory. I should say that's not the worst aspect of that provision. I haven't extracted the whole of Section 1309, but Section 1309, subsection 2, makes it an offence for a director or an officer not to take reasonable steps to ensure that information is not false or misleading, whether or not they actually know information is false or misleading in a material particular. Now, there are a whole range of defences to that, reliance and others and all sorts of things, but for someone at a senior level of a company, taking reasonable steps is a pretty difficult thing to do in the circumstances. The other thing to note is that Commonwealth criminal offences must be tried by juries. Okay, can't have a judge-only trial. And although I would prefer to be on Mr. Caldwell's side of these sorts of arguments, I couldn't confidently tell him that a jury looking at this, again with the benefit of hindsight and with knowledge of all that's gone on with these companies, wouldn't convict him. Stephen will just run you through what that would mean if he were to be convicted.
2 to 5 years for 1309. You could stab someone and get significantly less than that. Recently, Section 184, 1041G have been upped from 5 years to 15 years, which is a pretty serious stretch. The financial penalties have also increased. And interestingly, for corporations, the corporations fines used to be pretty minimalist, but now they've got quite serious. So you're looking at the greater of 9.45 million, 3 times the benefit derived from the contravention, if that can be figured out, or 10% of the annual turnover calculated up to the month of the contravention, which, if you think of something like Westpac, could be a fairly substantial amount of money. Because I think their quarterly profits are 6-7 billion. So their turnover would be fairly substantial.
Yeah, That's a big fine. That's a huge fine.
We'll breeze through this part. The point here is defending yourself against ASIC is super expensive, and a big commercial case will have hundreds of thousands of documents your lawyers have to look at. ASIC will put them all at you. And the good commercial lawyers are expensive. And so this is a first order issue for the lawyers because we need to get paid to do our job. And it's a first order issue for the defendant director. The Corporations Act doesn't prohibits companies from giving indemnities to people for certain things. And essentially what you can't do is indemnify someone for civil penalties they have to pay, compensation orders they have to pay, pecuniary penalties. So if they breach their duties to the company and are found liable, you can't indemnify them for that. And also you can't pay their legal fees if they're ultimately found to have breached the provisions or found guilty of an offence. That position's been clarified in a Victorian case which says you can pay legal fees to a director to defend themselves up to the point where they're found guilty or found to have breached it, at which point the director has to pay it back if they're done. And that is a significant problem for directors, because at the end of a big case it could be $1 million.
Likely to be much higher than the fine that's imposed on them. So it's a massive issue for directors. And although we've put this at the end of our talk, who will pay, this question is usually answered at the beginning of an engagement, because it influences everything directors do, and it influences how they might defend a regulatory action.
It also ties in with directors and officers insurance that the company has, because usually the director claims indemnity from the company will be claiming indemnity from its insurer, and the insurance will have limitations that mirror what's in the Corporations Act, because you can't pay insurance premiums that indemnify people, etc., for those things. There will also be other exclusions which the insurers will want to hold on to as long as they can, and usually what happens is the insurer will reserve their position, pay the fees, and then try and squeeze you later by threatening to deny indemnity to the company. It can be very complicated, and what it can also mean is that the bills start rolling in before the company starts indemnifying, and it can be very stressful. On top of all the other problems you have is the problem of paying.
Now, is anyone convinced that that being a public company director is fraught with risk, or do you still think that it's a cushy job that anyone could do? I submit to you that it is a job that I would never do unless I was absolutely desperate for a payday, a small payday.
What's a David Gonski quote? That the biggest risk public company directors used to face was getting done DUI on the way home from the meeting.
That's no longer the case.
Definitely changed.
That's no longer the case. Now, that has undoubtedly been true for a long time, right? There's always been risk in being a public company director, particularly a non-executive director is not familiar with the inner workings of the company. But there are degrees of risk, and I think that the risks for directors today are higher than they've ever been in our corporate knowledge. Our corporate knowledge, and people who go back further than me would probably tell you back to those days too. And if you don't believe me, I believe is a former Monash Law School alumni who may in a couple of weeks be our next Prime Minister. He said in a doorstop on the 8th of February, if no one out of the banks goes to jail, if no one gets prosecuted or charged, I think Australians will say there's been a cover-up, right? I'm not sure that's the most responsible thing for someone in that position to say. Which Australians is he talking to? Is he talking to the same Australians who would sit on a jury in judgment of these individuals? What hope does a director have in circumstances where people are making those sorts of comments? And I don't want to be unfair. I mean, it's not just him. Everyone's making those sorts of comments. But what hope does a director have that they'll get a fair and impartial trial, particularly if it's a criminal trial where they're judged by a jury of their peers? And our corporate regulator cannot ignore these comments. Our corporate regulator won't ignore these comments. It's the reason that they've changed the way in which they approach investigations and the way in which they prosecute people. It's the reason they've introduced the notion of why not litigate. It's the reason they're currently advertising for, as I understand it, 200 or 300 new employees in their enforcement division. And if anyone's looking for a job, it's a good place to go, right? Do some interesting work, pretend you're a policeman. And there have always been, in my experience, regulatory cycles where the corporate regulator is more or less active in terms of prosecuting people. I think the last cycle probably ended, in my experience, with the James Hardie case, which we were involved in. We acted for one of the non-executive directors, and in that case, ASIC spent about $13 million on the case from first instance up to the High Court. We spent a week in the High Court on that case, spent about $13 million on that case. And in the case of the non-executive directors, they were banned, so they were disqualified from managing corporations for about a year and received a fine of about $20,000 or $25,000. So when you balance $13 million against that sort of penalty, you ask, well, what's the point? It's sort of at around about the time that the James Hardie decision was being handed down. I think ASIC went back into its shell, and the same thing could be said about ASIC and Rich. The OneTel decision, where ASIC spent huge amounts in legal fees and lost. But this time does seem different. I think this time ASIC is like in an existential fight for its existence as a corporate regulator. I think it recognises that, and I think ASIC perceives, and the people that control ASIC perceive that whether or not it wins that fight will be judged by the director body count. That's what it will come down to. It's not good news for directors, very good news for lawyers, but it's bad news for directors. So I hope we've been able to convey to you some of the issues that directors face through the case study. I think we're way over time already. We're supposed to have a networking function. So maybe what we'll do is, if anyone's got any questions, Stephen and I will hang around for the networking function. If you've got lots of questions, we'll hang around beyond that. But thank you all for attending and for staying longer than you needed to.
Thanks.